This is Barry Zalma speaking for Claims School's Zalma on Insurance. Today I'd like to speak about how a demurrer is improper if allegations of a complaint is sufficient to state a cause of action. This is a case that allegedly has something to do with COVID-19, but really it is a case dealing with pleading. This is not a ruling on evidence. In the case called Marina Pacific Hotel and Suites versus Fireman's Fund, the Court of Appeals of the State of California was faced with a ruling on a demurrer without leave to amend when the complaint alleged all the elements required to allege a cause of action. For more than 2 years, the court's understanding of COVID-19, the infectious disease caused by the SARS-CoV-2 virus, and its many variants has evolved. Courts now think they know how it spreads, how to protect against it, and how best to treat those who have it. When a pleading alleges facts sufficient to constitute a cause of action, what we think we know, beliefs not yet appropriately subject to judicial notice, has never been a proper basis for concluding as a matter of law those alleged facts cannot be true and on the ground, sustaining a demurrer without leave to amend. The owners of Hotel Irwin and Larry's, a restaurant adjacent to the hotel in Venice Beach, and its owners and operators, collectively spoken of as the Insureds, sued Fireman's Fund Insurance Company, alleged that COVID-19 virus was present on and had physically transformed portions of the insured properties, direct physical loss or damage, within the meaning of Fireman's Fund's first-party commercial property insurance policy. The trial court sustained Fireman's Fund's demurrer to the insured's first amended complaint without leave to amend and dismissed the lawsuit, ruling the COVID-19 virus cannot cause direct physical loss or damage to property for purposes of insurance coverage. The Court of Appeal noted that the trial court's decision might be the correct outcome following a trial or even a motion for summary judgment. However, it concluded the decision was error at the nascent phase of the case created by a demurrer. The Fireman's Fund policy was issued on July 1, 2019 to continue until July 1, 2020 to provide coverage for the plaintiffs in this litigation who were named as insureds. A copy of the policy was attached to the pleading. The policy's general property coverage provision stated, "We will pay for direct physical loss or damage to the insured property caused by or resulting from a covered cause of loss during the policy period." The policy also included communicable disease coverage with a limit of $1 million, providing that the insurer would pay, quote, "for direct physical loss or damage," close quote, to insured property, quote, "caused by or resulting from a covered communicable disease event," close quote, including costs necessary to repair or rebuild insured property damaged or destroyed by the communicable disease, and to mitigate, contain, remediate, treat, detoxify, disinfect, neutralize, clean up, remove, dispose of, test for, monitor, and assess the effects of the communicable disease. The first amended complaint alleged in part the insureds, beginning in March of 2020, had suffered loss arising from direct physical loss or damage to covered property based on the existence of COVID-19. They asserted that COVID-19 is a covered cause of loss under the policy because it is not excluded or limited thereunder, and on information and belief that the presence of COVID-19 on property, including on and within the insured properties, that is, an external force, caused and continues to cause physical loss and or damage to property by causing, among other things, a distinct, demonstrable, or physical alteration to property, and by transforming the physical condition of property at the insured properties and within the covered radius, causing the properties to remain in an unsafe and hazardous condition. The physical loss or damage to property the insureds alleged required the closure or suspension of operations at Hotel Irwin and Larry's, or portions of those properties at various times, and caused them to incur extra expense, adopt remedial and precautionary measures to attempt to restore and remediate the air and surfaces at the insured properties, dispose of property damaged by COVID-19, and limit operations at the insured properties. Fireman's Fund demurred to the first amended complaint and argued the insureds had failed to allege facts showing direct physical loss or damage to covered property, a contractual prerequisite for a valid claim to benefits under the policy. The court found, quoting the mortality and disease exclusion, that the Fireman's Fund policy contains an express virus exclusion provision. This provision expressly excludes coverage of any direct physical loss or damage resulting from a virus. It is beyond dispute that COVID-19 is a virus. The Court of Appeal reasoned that the governing law on the interpretation of insurance policies requires that, in general, interpretation of an insurance policy is a question of law that is decided under settled rules of contract interpretation. The insured's appeal requires analysis of all the allegations in their first amended complaint, primarily in terms of one insuring provision, coverage for business interruption due to direct physical loss or damage to covered property, and one exclusion for mortality and disease. The Court of Appeal concluded that the insureds adequately alleged direct physical loss or damage caused by the COVID-19 virus and a cause of action for breach of contract by Fireman's Fund. The court reasoned that the elements of a cause of action for breach of contract are the existence of the contract, plaintiff's performance or excuse for non-performance, defendant's breach, and the resulting damages to the plaintiff. Fireman's Fund's demurrer did not challenge the first, second, and fourth element, contending only it did not breach its obligation to pay benefits under the policy because the insureds, having failed to allege any direct physical loss or damage to property, failed to allege a covered loss. To reiterate, with respect to covered losses, the insureds alleged in their first amended complaint COVID-19 not only lives on surfaces but also bonds to surfaces through physiochemical reactions involving cells and surface proteins which transform the physical condition of the property. The virus was present on surfaces throughout the insured properties, including the hotel lobby, kitchens at both the hotel and the restaurant, employee break rooms, service elevators, and parking garage, as well as on the property's food, bedding, fixtures, tables, chairs, and countertops. Because of the nature of the pandemic, the virus was continually reintroduced to surfaces at those locations. As a direct result, the insureds were required to close or suspend operations in whole or in part at various times, and incurred extra expenses. They adopted measures to restore and remediate the air and surfaces at the insured properties. The insured specifically alleged they were required to dispose of property damaged by COVID-19 and limit operations at the insured properties. Assuming as the court must accept as true when dealing with a demurrer the truth of those allegations, even if improbable, absent judicially noticed facts irrefutably contradicting them. The insureds have unquestionably pleaded direct physical loss or damage to covered property within the definition articulated in a distinct, demonstrable physical alteration of the property. The plaintiffs also adequately alleged that physical loss or damage caused a slowdown in or cessation of the operations of the insured's business while the covered property was restored or remediated, thereby triggering their business interruption, business income, and extra expense coverage. Even if there had been evidence subject to proper judicial notice to establish the disinfecting, repaired, and alleged property damage, it would not resolve whether contaminated property had been damaged in the interim, nor would it alleviate any loss of business income or extra expenses. Fireman's Fund's argument and the trial court's conclusion that the COVID-19 virus cannot cause direct physical loss or damage to property are directly undermined by the policy's plain language establishing communicable disease coverage. Fireman's Fund asserts that the insureds must allege an obvious physical alteration, for example, broken chairs, dented walls, or smashed windows, to adequately allege direct physical loss or damage, because it is undisputed that the COVID-19 virus, or presumably any communicable disease, does not cause such damage. Construing the policy provision together as the appellate court must, this language precludes the interpretation that direct physical loss or damage categorically cannot be caused by a virus. If, as the trial court ruled and Fireman's Fund argues on appeal, the policy's mortality and disease exclusion bars all loss or damage caused by a virus, then it would be immaterial whether the first amended complaint alleged facts showing direct physical loss or damage to property from the COVID-19 virus. The policy issued to the insureds did not contain this virus or bacteria exclusion. Instead, as discussed, the exclusion provided only that the insurer would not pay for loss, damage, or expense caused by or resulting from mortality, death by natural causes, disease, sickness, any condition of health, bacteria, or virus. Particularly when compared to the all-encompassing language of the ISO virus exclusion, the most reasonable interpretation of this language is that it precludes coverage for losses related to death from any of the listed causes. That is, it excludes losses resulting from a death caused by a virus or other disease, and not, more broadly, any otherwise covered losses resulting from a virus or a disease. At the very least, the language is ambiguous. Absent extrinsic evidence of the parties' expectations, hardly surprising given the preliminary stage of the proceeding, the exclusion must be interpreted narrowly, at least for now. If all losses caused by a virus were excluded, even those indirectly resulting from the virus, as the Fireman's Fund contends, the communicable disease coverage would be meaningless. The whole of a contract is to be taken together so as to give effect to every part, if reasonably practicable, each clause helping to interpret the other. We do so by holding the mortality and disease exclusion does not bar the insured's claims in this lawsuit. The Court of Appeal acknowledged it might be more efficient if trial courts could dismiss lawsuits at the pleading stage based on the judge's common sense and understanding of common experience, rather than waiting to actually receive evidence to determine whether the plaintiff's factual allegations could be proved. But that is not how the justice system works in California. Because the insureds adequately alleged losses covered by Fireman's Fund's policy, they are entitled to an opportunity to present their case at trial or in opposition to a motion for summary judgment. The judgment was reversed, and the cause remanded with directions to the trial court to vacate its order sustaining the demurrer without leave to amend, and to enter a new order overruling the demurrer. The insureds were entitled to recover their costs on appeal. In my opinion, although press reports consider this decision to be a win for plaintiffs, it is not. It is a statement that the plaintiffs adequately pleaded a cause of action that, if proved with admissible evidence, can result in coverage, and that the plaintiffs are entitled to try to prove their case. At best, it is a decision that the mere allegation of direct physical loss is sufficient to this Court of Appeal to avoid a demurrer, but that evidence is still required to avoid a motion for summary judgment or the verdict of a judge or jury at a time of trial. Thank you for your attention, and consider the fact that I've just published Random Thoughts on Insurance, Volume 14, a collection of blog posts from Zelma on insurance.